is a feature address, the first for today's events on the internet, law, and society. And to moderate that session, we're going to have Mr. Donovan Walker, who is an attorney at law and has been for over 27 years. Donovan is the managing partner of the firm Hart, Muirhead, and Fata. He practices in areas of corporate, commercial, maritime, real estate, mortgage financing, mergers and acquisitions, and other areas of law. Has a very diverse practice. Donovan has also served as the president of the Jamaica Bar Association from 2014 to 2016, and he's currently the president of OCBA. Donovan?
We're going to be hearing from our keynote speaker, Mr. Dan Shefet. And before we ask Mr. Shefet to speak, I have the honor of, first of all, introducing Mr. Shefet, and I'd like at this stage to also introduce our discussants. But first of all, as you all may know, Mr. Shefet is an attorney at law and practices in the courts in France, and in particular, the Court of Appeal in France. He's currently the advisor to the Council of Europe for the Internet Ombudsman. He's the founder of Cabinet Shefet, a firm focused on international law, including European law. He's a French lawyer born in Denmark and holds a philosophy degree and a law degree from the University of Copenhagen. In 2014, he founded the Association for Accountability and Internet Democracy. His very impressive resume shows his work in human rights, the IT environment, and he has been the author of many papers and has spoken extensively worldwide on the issues of internet and technology. As discussants, we also have Senator Anthony Vieira, who's an independent senator in Trinidad and Tobago in their parliament. He's an attorney at law since 1983, studied at the University of the West Indies Faculty of Law and the Hewarding Law School and the Institute of International Relations, and is a certified commercial mediator. Senator Vieira has served on numerous parliamentary committees and has held various appointments, including legal consultant to the Minister of Education, member of the committee responsible for the review and draft of the Telecommunications Bill, and member of the Code of Ethics Grievance Committee of the Trinidad and Tobago Chamber of Industry and Commerce. He was a member of the Ministerial Committee appointed to implement the draft National Intellectual Property Policy. And again, Senator Vieira is very well known in Trinidad and Tobago and has a robust practice in intellectual property and commercial law. And finally, but certainly not least, our final discussant hails from Belize, and that is our colleague Naima Barrow. Ms. Barrow is currently an advisor in the legal sector for the Caribbean Agency for Justice Solutions. She's a well-known attorney at law in Belize and indeed throughout the region because of her robust practice at the Caribbean Court of Justice. She's a notary public for Belize, and Ms. Barrow studied at the UWI Cave Hill and the Norman Manley Law School and was called to the bar in Belize in 2005. She has an extensive practice in the courts of Belize and a robust practice at the CCJ. And colleagues, friends, what is very interesting relating to data protection is that some of the issues that we have had to deal with in the Caribbean, ranging from privacy issues, misstatements in and about the internet, abuse of technology, failing to make certain disclosures, breaching certain basic principles, and a complex raft of legislation throughout the region. In Jamaica in 2020, our Data Protection Act was passed, and that is a very robust legislation, still waiting on regulations, by the way. And so we have all of these issues. They are important issues and issues that will touch and concern the practice of law in our region. And so it really is important for us to hear our discussants and to listen to them speak about internet law and society. So it gives me great pleasure to invite Dan to kick us off this morning, and then we can invite our discussants to consider what Mr. Shefet has to offer to us, and we really look forward to it. So Dan, over to you.
Well, thank you. Can you hear me now?
Yes, I'm hearing you perfectly.
You can hear me. Okay, fine.
Yes, quite clear.
What a wonderful pleasure to be with you, except I would have preferred to be there in person. It's almost 4 o'clock here in Paris. It's a rainy and cold day, and I can't imagine what it would have been like being with you all in the Caribbean. I never had the pleasure of actually visiting the Caribbean as such, except for the French Antilles, obviously, and the Dutch Antilles. So let's work on that. I want to go and see you all, and I shall be looking forward to that. Now, so what I have to tell you today is that the subject that I've been given is of course enormous, and I have something like 5 or 7 minutes to kick off the debate. And I hope that we'll have a really serious and solid and robust debate, because some of these subjects are not only law, but also policy. But the subject is really, how does technology affect the legal profession? And here I speak as a legal practitioner more than as an advisor to the Council of Europe, to UNESCO, to the Mahatma Gandhi Institute for Education and Peace, and other institutions that I happen to be the advisor of. I'd speak to you as a lawyer in private practice, because this is really what I believe that you expect that we start sort of like discuss, which is how does technology affect our profession also. Now, the first interesting thing is that we talk about technology, but in reality, we're not talking about technology, we're talking about the internet. Those are not the same things, but it seems to be, and that's very symptomatic, isn't it, that technology today is the same as the internet. Of course, I'm making this remark not only because I want to make a semantic remark, but also because I want everybody to understand, please, that there is much more out there than the internet, much more out there. But what I should be focusing now is, how does the internet affect the legal work as a lawyer in private practice, and also the judges? Now, you should know that before giving you what I wrote down here on a piece of paper, which I hope I can read, a list of the sort of inventory that I took down of areas that affect our profession, you should know that within the European Union, our executive branch, the European Commission, has given the regulation of the internet a top priority. It has given it a top priority for several policy reasons, and one of them is national sovereignty. National sovereignty is really a major challenge to the European Union. And of course, the national sovereignty we're talking about is allowing European alternatives to what is today viewed, and justifiably so, as American control of the internet, and to a very large extent of technology. It has a lot of cultural implications and a lot of economic implications. And the European Union wants to be able to stand up against this. It's almost like it's a commercial warfare. It's almost that. Wants to stand up against this and allowing its own industry to develop alternatives to the Silicon Valley giants. Now, of course, it's going to be extremely difficult. I don't see how anybody can enter the market today, seriously challenging the likes of Google and Facebook. But at least the European Union wants to create the economic and the legal framework allowing that in the name of national sovereignty. So there are 3 acts that are being drafted now, that are being discussed now within the European Parliament, the European Commission, the Council of Europe, which is really the Council of the Ministers of the 27 member states, because of, obviously, as you know, The UK unfortunately left us. And these are going to be extremely important regulatory acts. There will be regulations, which means that they will apply directly in each and every member state. They will not have to be transposed like directives have to be transposed. And if anybody's interested in me developing on European law, I'd be glad to do so, but it's maybe not the right thing to do for an introduction. But the point I want to make is that these acts will be regulations, so they will apply directly in each and every member state. Now, everybody knows about the GDPR, the General Data Protection Regulation, which came into effect on the 25th of May, 2018. It's over 3 years now, and we have a lot of experience on the GDPR, and I'll get back to some of that, how it affects our life as lawyers in private practice and our judges. But I'm mentioning here, by way of introduction, to say that the ambition of the European Commission is that the following 3 acts or draft regulations will have the same impact. So the first one I mentioned is the Digital Governance Act. The Digital Governance Act, to simplify, and I invite you to check them out on the internet if you so wish, or I can send you a PDF on them, just let me know. The Digital Governance Act is really an act which would allow ultimately the European alternatives that I mentioned, and one of the prime and also politically controversial parts of that draft is the so-called compulsory licensing section, which really, and again, I'm oversimplifying this, but it really would allow or would oblige companies like Google, Facebook, and their likes to license data to alternatives in Europe. It will start first with the public sector, and then we would move on to the private sector. Obviously, one of the main problems we have here is what is the royalty or the payment that will have to be paid, because this is somehow protected. Actually, it's another big question as to what extent is data protected in terms of intellectual property rights. Maybe we will have time to go into that really interesting legal and philosophical question afterwards. But no doubt there is some sort of protection. Maybe it's database protection because we have a special database directive in the European Union. Whatever it is, you can't just oblige companies to share their crown jewels with other companies without getting payment for it. That would be expropriation and would raise all sorts of difficult legal questions. But so obviously, if this Digital Governance Act finally passes, the European Parliament probably will, we will have to figure out what the payment would be. So this is one very, very important piece of legislation. The other one which is coming down is the Digital Market Act. The Digital Market Act is really an act which will regulate competition. Competition in the sense that we all know that antitrust legislation in the US and competition law in Europe is not adapted in any way to what's happening on the online economy, mainly because online services are for free. So what is the harm done to the competitor in terms of the abuse of a dominant position? I mean, it still remains free, doesn't it? So and the typical test, which is that if you can increase your price over your unit price over marginal cost, then that is an indication that you are over average marginal cost, or that is an indication that you enjoy a dominant position. That doesn't really apply to the internet. So we need to have special rules on the definition of dominant position and competition for the online economy, and the Digital Marketing Act is trying to address that. This is not to say that we haven't had cases in Europe, very famous antitrust cases, both against Google and others. The antitrust commissioner, the competition law commissioner in Europe, Margrethe Vestager, has already fined Google on several occasions, and I think the total now runs in excess of $8 billion. But all of these are being challenged by these companies before the European Court of Justice, and it will be extremely interesting to see what these decisions will be as they come down. And then we have the Digital Services Act, which I am heavily involved in as the advisor to the so-called rapporteur in the European Parliament, because the Digital Services Act deals with liability and liability for content, and that's really my main personal interest, and therefore also relates to most of the cases that I'm dealing with. The liability for platforms, the liability for search engines, the liability for social media, and so on and so forth, for content. Very complicated issue, as you can imagine, because it's pitted directly against free speech in the US, which is more robust than typically in Europe, but certainly we have robust legislation in Europe. For instance, Article 10 of the European Convention of Human Rights, which is almost the same as Article 19 of the ICCPR and the Declaration of Human Rights. But this is extremely complicated. Liability for third-party generated content. It brings us to issues like hate speech and so on, where in Europe we have a tradition that they don't have in the US. This is a good example of what I said before of the specificity of the European culture as pitted against the US culture, because this is really a cultural phenomenon. There was this famous, as you probably know, Marxist Italian philosopher, Antonio Gramsci, who talked about cultural hegemony. Of course, cultural hegemony, back in Gramsci's days, related to the bourgeoisie, as we call it, against the proletariat. But you may view, from the European perspective, that the cultural hegemony today rests with Silicon Valley. Now, all of that, just to tell you that that's in the works. Now, I promised to give you an inventory of how does all this affect the legal work in private practice. And again, I just jotted down some of the stuff that affects me when I do my work. Now, the first thing that I would say is like cross subjects. It's evidence. It's IT forensics, which is a really complicated and developing field, not only in terms of traditional court cases, but also in terms of cyber crimes. We see that our judges are becoming more and more familiar with IT forensics. We also have some experts that are very, very, very well versed in this, but we also see that the legal profession needs to understand much more what can be proven, what kind of evidence can be tampered with, and so on and so forth. Unfortunately, the whole area of IT forensics is something which I don't see many law schools provide as serious and robust as special courses. We need that almost urgently. It comes up in almost all cases, a question of IT forensics. And I may say that from private practice, I encounter that pretty often. Another area where I see the technology in the sense of the internet affecting our legal work is in public law. Public law, which now, especially in Europe, includes an obligation for what we call open government, which means that it's not just a question of transparency and digitalization of your personal information and so on the internet, but that it has almost become a new way of legislating. That is not in any way reflected in our constitutions. Our constitutions are hopelessly outdated. The Constitution of France is from 1958, and we don't have any constitutional requirements for transparency or, of course, the legislative process that is very, very often now taking place on the internet, which does create interesting legal problems as to whether a law actually, when it was enacted, followed the procedure or not, because some senators and some parliamentarians do commit mistakes and forget that there is actually a constitution that does commit them, that does oblige them to publish laws and draft laws in a special legal gazette, and so on and so forth. Then there's the health sector, which of course COVID has taught us a lot about. Enormous focus on that. I've had 2 cases dealing with traceability of COVID on special applications that the different European governments have imposed upon citizens to use. I use the word imposed because there was no choice. Very interesting, all human rights questions that we encounter here. Contract law, something as fundamental as contract law. Just look at the way that we see the fundamental concept of consent developing, right? Consent in the traditional legal term is certainly not what we see. I would venture to say that on the internet today where we just accept anything without reading it. Everybody knows that. It's a complete fiction to assume that anybody reads anything on the internet when they just click OK. But you have given consent, or haven't you? And so on and so forth. We need to, in private practice, this is becoming an increasing problem, which sometimes is regulated in terms of consumer protection. And if you're not consumers, but if you are to professionals, we don't have any direct regulation of that. Liability, I mentioned before, also something that we see increasingly in the courtrooms. I mentioned before content liability, which is the liability that the Digital Services Act sees to deal with, which is liability for third-party generated content. The example given is, of course, hate speech, but there is other kinds of vicarious liability, which would be intellectual property infringements, hyperlinks. We have some important cases dealing with that for the European Court of Justice, but we still have a long way to go in order to understand what the law actually is. Not to mention illicit products, which is also a growing problem, not only on the darknet, but also on some of the social media platforms that I can tell you a lot about, where we get an increasing number of cases for forgeries and for drugs and for the sale of protected species, and archaeological theft from war crimes and so on and so forth. Anything that you can sell and buy on the internet, and what is the responsibility for the platforms that actually help the individuals sell and buy these products. So this is illicit products, which is of course a separate category from that of illicit content, but it's the same kind of liability platform that we need to develop. The profiling of judges is something that I'm very, very interested in. And if you're also interested in it, I'd be glad to share an article that I wrote for the American Law Institute on a French legal initiative, which is Article 33 for the special law on the programming of the justice sector for the next 4 years, where actually the French law prohibits profiling of judges. Now, just imagine that it's very hard to understand what the whole purpose and the reasoning of that law is. I mean, the stated reason is that if you profile judges, you will be able to predict what their decisions may be or may not be. I would say that that's a good thing, not a bad thing. So you see where I'm coming from. And this whole thing about using artificial intelligence and so on in the legal system is becoming an increasing challenge. I would actually, and also suggested that to the European Commission, turn the whole thing around and say that it's not a risk to objectivity to use artificial intelligence, which we all know can be biased, but it's actually the opposite. It would give us a quick and a fast-track remedy in case somebody feels that he has been the victim of a miscarriage of justice. But we need to legislate that. We need to make sure that artificial intelligence, not only in terms of profiling judges, but also of assessing evidence and so on and so forth, can be used in an intelligent way. Compliance. Compliance is also becoming an increasing problem in private practice, because there are a lot of new compliance, a lot of new legislation on compliance on the internet that we didn't have before. Is becoming a major threat to many companies. And I would also mention just another one, which is a classic of law, which is labor law. I mean, just here in Europe, and in particular in France, where we're known to have very strict and very protective labor laws, the way that we saw with COVID, of course, that accelerated the process of remote working, it's extremely difficult for the employers to understand now what are their rights and obligations, and it's also for the employees when they're working from home and so on and so forth, and monitoring work before your computer screen and so on and so forth. What are the rights and obligations of the employees? We get an increasing number of cases. And again, it's of course the good side is that you feel that you are creating law by dealing with these cases in the first time, but in private practice, you would sometimes prefer to have some precedent or some legal framework to work against. Extraterritoriality was mentioned in the context of jurisdiction, and this is of course an area which I personally find the most interesting. Extraterritoriality is a problem that we've always had. I mean, we all know that the leading case, the Lotus case from the Permanent Court of Justice under the League of Nations. Goes back to the 1920s, and that's still the leading case under international law in terms of extraterritoriality for penal law. But that's completely outdated, obviously. And what we see now is extraterritoriality or clashes of laws, as it were, increasing. We find it almost every day in some jurisdiction in Europe, and mainly the clash is between the US and the famous or infamous Communications Decency Act, Section 230C, which I'm sure you know about, which is the Bible for the internet, which really gives them the complete immunity. We have different laws in Europe. We have laws in France and in Germany that regulate speech and that do it directly on the internet. And very often we get into clashes where, of course, the provider is based in the US and the law or the violation of the law takes place in Europe. So what do you do? What do you do in that particular situation? Does it or does it not violate the First Amendment? And how does all this play out? Very complicated. I can tell you about the leading cases on that later. I'm sure it's a subject that will interest you just as much as it does in Europe. And of course, a problem that is growing. One of the examples, and maybe that would be the last because I'm already speaking too much, would be a case that I'm working on right now, which is a clash between the GDPR, which again is the General Data Protection Regulation that protects privacy on European so-called data subjects. That's the terminology of the GDPR, data subjects, which are being the subject of a discovery order in California. That discovery order, if the data subjects were to have that data disclosed, would simply violate the GDPR because in that particular case, there is no so-called adequacy. There's no agreement allowing the transfer of data across Atlantic from Europe to the US, where it is not protected the same way as in Europe. On the other hand, since we have a discovery decision, we may encounter fines if we don't live up to that discovery decision. So what do? We're between the rock and a hard place. Either we violate European laws or we violate American laws. So I may have spoken too much already, and I hope that this may kick off a debate. There are lots of subjects. And again, I hope very much that next time I should be sitting next to you on the beach in Barbados somewhere, having a great time and hopefully joking about all this.